Is the Supreme Court setting itself up as a dictator here in the United States? Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So since I've been in college, I've been concerned about the role that the Supreme Court plays in our society. In a country that's supposedly democratic, such immense power given to a body of unelected, privileged elitists that they can exercise for the remainder of their lives is something that was deeply disturbing to me. At least, I could say to myself, the Supreme Court supposedly follows a higher authority, that being the law, and they're supposed to remain loyal to that. Well, that was the case up until recently, when we have been faced by what Ruth Marcus of the Washington Post called a radical and impatient court. This is a court that shows absolutely no respect for precedent. It matters not that a law has been in effect for 50 years or more for the court to simply discard it because they don't like it anymore. We saw that last year with the abortion case, and of course this year with affirmative action, and to slightly less fanfare, the Clean Water Act. In some respects, the Clean Water Act case is even more shocking because the court so completely disregarded the clear intent that Congress had when it originally passed the legislation. In other words, the court is basically putting itself above the wishes of Congress at the time that the legislation was passed, saying, we know better than you, despite the fact that you were elected and we weren't. But ironically, despite the fact that the affirmative action case and the Clean Water Act case were perhaps the two most outrageous results, there are three other cases that really stood out to me as sending a disturbing message. And that message is that this is a court that views itself as the dictatorship that will lord its wishes over the rest of America. What three cases am I talking about? Well, I'm talking about first, the student loan case, in which a majority of the Supreme Court held that the president did not have the authority to forgive up to $20,000 in student loans owed by Americans across the country. The second case that I find particularly disturbing is the 303 Creative case, in which the court held that a Christian web designer did not need to produce websites for LGBTQ couples. Finally, and many people might find this disturbing, or at least surprising, the voting rights case, in which the majority actually held that the Alabama gerrymander was unconstitutional. The reason I say many might find this surprising is I did breathe a sigh of relief when this case was handed down. And what's more is I see it as a real opportunity for Democrats, in that the holding from this case will require a whole host of states, including Texas, Florida, and Georgia, as well as potentially Wisconsin, to reconfigure some of their congressional districts in a way that make them less skewed towards Republicans. But there was an underlying message in this case that I found deeply disturbing. So let's talk about these messages. First of all, as I stated earlier, part of the reason that the court gets to exert this authority, despite the fact that it's an unelected body, comes from the idea that they're supposed to follow the law. A fundamental guardrail for that is that the court is only supposed to consider actual cases and controversies. In other words, the court isn't supposed to step in and make policy. The court is supposed to adjudicate when you've got two parties who've been harmed or who have the potential of being harmed, and the court has to decide how the law essentially divides the harm between the two parties. Now, the reason the student loan case really disturbs me in this regard, and Justice Elena Kagan raised this issue in an absolute barn burner of a dissent, is that even if we agree that President Biden might have overstepped his authority in granting the student loan forgiveness, and I will grant that this is a gray area up for debate, and that President Biden, frankly, probably would have rather not taken this approach and would have preferred Congress to have done something to forgive student loans. But Congress, of course, didn't have the votes to do so. And President Biden was being pressured by groups urging him to take that step. And so he did, opening this Pandora's box. But the biggest problem that the plaintiffs had in this case was something known as standing. Now again, this comes back to the actual cases and controversies idea, which means that for a party to bring a case, they actually have to be harmed. They actually have to have some reason that they're bringing this case, not simply that they don't like the fact that somebody has done something. If that were the case, then courts would be making all kinds of crazy decisions all over the place. And so this is an important guardrail against courts setting policy, in that they actually have to have two parties before them who've been harmed or have the potential to be harmed by a certain action. Well, in this case, the complaint was brought by the state of Missouri, the Attorney General for the state of Missouri. And they argued that one of the loan servicers, called Mohila, used to be an arm of the state of Missouri, although it no longer was, and that as a result, the state of Missouri potentially was harmed because Mohila, which again is no longer an arm of the state of Missouri, could lose people whose loans it was servicing. That was their claim to a harm. Now, Mohila, for their part, said they're no longer part of the state of Missouri, and they don't agree with Missouri pursuing this action. But yet the court completely ignored that, completely ignored the issue of standing, and just went directly to the issue at hand. Now, you might say, well, if you agree with the court's position, well, that's okay. The problem is, as Elena Kagan pointed out in her barn burner of a dissent, she wrote, "From the first page to the last, today's opinion departs from the demands of judicial restraint. At the behest of a party that has suffered no injury, the majority decides a contested public policy issue properly belonging to the politically accountable branches and the people they represent." So in other words, Elena Kagan is calling out the majority, saying, this is a public policy issue. Let the elected officials decide this. This is not something the court should decide because there's no party before us who's had a harm. She goes on, that is a major problem, not just for governance, but for democracy too. Congress is, of course, a democratic institution. It responds, even if imperfectly, to the preferences of American voters. And agency officials, though not themselves elected, serve a president with the broadest of all political constituencies. But this court, it is by design as detached as possible from the body politic. This is again Elena Kagan in her dissent. That is why the court is supposed to stick to its business, to decide only cases and controversies, to stay away from making this nation's policy about subjects like student loan relief. In other words, what Elena Kagan is pointing out is the fact that this court now says no longer does it have to have some issue before it where it's deciding between two parties. It can literally step in and decide public policy based upon its own policy preferences, even though they have no constituency. As Justice Kagan points out quite correctly, the agencies, the ones who are arguing that they have the authority to make this decision based upon prior authorization from Congress, work at the pleasure of the president, who is elected by all of us. So there's the democratic connection, small d democratic connection. The court, however, is just going to do whatever it wants based upon its own policy preferences. Now, if you think that this is overly hysterical on my part, just look then to the 303 Creative case. This is, again, the Christian website designer who didn't want to design websites for LGBTQ people. Here, it turns out that the case was based entirely upon a fiction, that this website designer was never asked to design a website that somehow offended their religious beliefs. They simply made up the situation. So again, we see a situation where the Supreme Court just steps in and makes pronouncements on issues that then we need to live with, despite the fact that there's no case or controversy before it. And that now brings us to the Alabama gerrymandering case. Now there, at the same time as Justice Roberts was writing that Alabama had overstepped its bounds by essentially creating a racial gerrymander that basically put all the black voters in the state into one congressional district, ensuring that the state would have 6 majority white and thereby Republican districts and only 1 majority black and thereby Democratic district. And Roberts made a similar point also in the case brought by North Carolina, in which North Carolina sought to read the Constitution to say that state legislators are the only ones with authority over elections. Again, another case where I breathed a sigh of relief. But in those two cases, the court made it clear that the Supreme Court has ultimate authority over elections. In fact, in Moore v. Harper, they even made it clear, citing that infamous case Bush v. Gore from the 2000 election. for the proposition that ultimately the U.S. Supreme Court can step in and overturn findings by state courts when it comes to elections law if they don't like the result. Well, we all know what happened in Bush v. Gore, and that just shows how an ideological court can simply step in and say, we don't like the way the voters voted, and instead we want to impose our own priority. Again, you might say I'm being overly hysterical, but just look at the cases here to see what's going on. You put these cases together, and you have a court that is unrestrained by the law, unrestrained by the requirement that they actually have a case in controversy. Instead, that if they simply don't like a policy, they can step in and change it. And that says they can step in and overrule state courts when it comes to their elections. That, my friends, is the making of a dictatorship of the court. And Justice Kagan was quite right to raise concerns over the impact that this philosophy has upon our democracy. Well, if you want to see more about what a nasty negative force Justice Alito is on the Supreme Court, check out this video over here that I did a little while ago. I'll see you then. In the meantime, let's hope for continued progress. Thank you.